Dag number 3, that is CSC Limited. And my page 54 is the dag number 2, CSC Limited.
Yes.
And my order passed by the Honorable High Court is page 41 in earlier occasion.
41.
41. 41 starts 1 and 41. Relevant portion page 46. 46. Third para. After hearing learned advocates appearing on behalf of the parties, this writ application is dismissed.
So you are petitioners in this petition.
I am the on that petition. Directing the land collectors House Joint Borgonas to make an award of within 30 days from the date of publication of this order and to release compensatory terms of the award immediately after the award is released.
Yes, Mr. Bandhavata.
Well, your lordship, kindly take up page number 4, paragraph 3. What he has taken. May I read, Milord? In the year 1995, the petitioner found boundary walls are being raised around the lands of the petitioner, and from the respondent authorities, the petitioner came to know by a gazette notification dated 31st March 1994, the respondent authorities gave a notice of requisition of the land situated near village Pujali and Rajarampur, including the petitioner according to question number 23, jail number 41, Rajarpur, RS plot number 1 for construction of thermal power station at the Bajbaj. Gazette notification P2. Well, in the instant case, the subject matter is plot number 1, not the other plot numbers. Thereafter, my lord, your lordship kindly turn to page 4, P4, page 33. It is de-requisition.
Page 33.
Page 33. P4. May I read, Milord? With reference to the above, it is to inform you that the total area measuring 0.780 acres of land of plot number 1 of Moja Rajarampur, jail number 41, PS Bajbaj, district 24 Coronas has been acquisition under the provision of the Land Acquisition Act 1894 Act 1 for the purpose of construction of Bajbaj thermal power project of the CAC. And final award was declared, but the payment of award in respect of the said plot has not been done due to the requisition proposals of the plot from the RB. However, the said requisition proposal has yet to be finalized, recording such and such Milord.
Yes.
Next Milord, page 34.
Yes.
What is his representation? What is the representation of the petition? That is only here plot number 1.
Yes.
What are other plots, Milord? With due respect, I inform you that on behalf of my brother, Nibendranath Kanat Satamsat, owner of plot number 1, Kutyana, so I request you to kindly arrange information certificate which is acquired or not or other purpose such and such.
So this was also in plot number 1.
Next Milord, next paragraph. Subject matter Milord. Unauthorized occupation of land comprising RS plot number 1. Moja Rajarampur, jail number 0. Under the instruction of my client, I am state that my client is the owner of the above plot, RS plot comprising an area land more 9.93 decimal, which has been unlawfully occupied by your department function for the purpose of construction of the Bajbaj thermal power. With this note, it is stated the land acquisition collector proposal has not yet been started. Next, Milord, page 40. P6A. It is, my lord, supplied by the special land acquisition of 24.
Dag number 1 has not been acquired. Till date. So this is in 2008. Then,
my lord, therefore, my lord, his prayer is otherwise, my lord. In respect of other plots. Therefore, my lord, the reputation is not maintainable.
But how come, please kindly come to page 52.
52.
So, that number 1 has not been acquired.
Yes, my lord, it appears in the record.
But how it has been recorded in the name of CSC?
Yes, my lord.
How it has been recorded?
Doc number 23, page 40, it starts from page
No, page 52. Please kindly come to page 52. 52 refers to plot number 1.
My lord. Yes, my lord, doc number 1, that is my lord. So their number 115 CSC.
How can it be recorded?
My lord, total area of land is my lord is different.
Entire 16.
No.
78.
78.
How
Total
could
land
it
93, out of which I don't know my lord. Then I have to know.
No, you have said that number 1 has not been acquired. You have not said part has been acquired.
Yes, my lord. As it appears from the record, my lord.
But then how can it be recorded in the name of CSC?
Then I have to take effect in my lord. The CSC can answer this, my lord.
Yes.
The notification has been published on 1994. The notification has been published on 1994.
Notification under which section?
Because the petitioner himself annexed.
Under which section notification has been published? 41A. So 41A is the acquisition notice. How have you got this property? That number 1?
Thereafter 2000, we have executed, the government has executed deed of transfer.
Deed of transfer.
Yes, if you see page number 9, Lordship, the schedule.
Page number 9.
9.
Not legible. RS plot numbers 1. Area.
We have also paid the compensation, Lordship, to the collector.
You have deposited the amount. So Bandhavada, how can
Big
this?
instruction from the
What instruction? What is information? For that I directed you to take instruction.
I sought for instruction about the date period.
That is
No. You have supplied the wrong one. Incorrect copy.
The plot number which she has mentioned is not mentioned in this copy. এটা তোমার কাছে তো এই কপিটা নেই আমরা
अरे वो कॉपी सेम कॉपी
report and document your email for before Wednesday over
on her allegation is this CSC has ready construction below on
the picture. What that is in my
The Bandhavada, your information is that it has been de-requisitioned. But otherwise, these documents, you have executed a deed.
Yes.
How could you?
Well, I shall take instruction. I sought for instruction, but what she did I have not received. Top time to be given me not in the meter.
Malad the petitioner, Malad 72 years old. Malad.
But madam, in the writ petition, as it goes, you have your case is again only RS plot number 1.
55. No, Malad RS plot number first day একবার for that reason writ application has been filed regarding one. Then my lord,
Not your case. All documents are with regard to RS plot number 1.
all that one writ application already decided. My lord, if you not see the order, when the order has been passed, kindly see for a moment. The order has been passed. When my lord, that order has been passed, my lord, in respect of plot number 1. My lord, that is page 46.
You go to plot number 1 because
লেখা আছে এখানে। Malad, these all the documents are
Only this was in regard to plot number 1.
Malad, the writ petition. On that writ petition, Malad, plot number are there because these are the documents. Malad, I have writ application, certified copy of the writ application. Like this is the signed copy of the plan.
Yes, this is with regard to arrest plot number 1.
Well, it's also take master control. A copy of the
The petitioner claims to be Item number 23. Yes. Use the microphone. He is a busy counsel. Yes, please start. Yes, what is this matter? Oh, what short passover? How many minutes? 5 minutes? 3:15? 3:15. Yes. Next. Number 24. Respondent? Yes. Yes, where is the KMD? Yes. Yes, sir. Any affidavits were directed to be filed? No.
No, not
Only instruction, sir. Yes, yes. Sir.
I must answer that. You asked me on the last occasion to explore the possibility to mitigate that. Lord, I have tried my level, and the authority also tried. But the authority came
Who is
to
coming in the way?
this illegal act, this petitioner is standing in the way, allowing this act to will subsist. This will not only create a precedent, but also the authority will be responsible for other in other way also. Because this petition, Russia will find that the first order must be passed on 8th January.
8th January is not the first order.
That's the second.
First order is 5th of January.
Then 8th January. I am referring to the 8th January.
8th January only to take further instructions. Yes, what do you want to submit? Yes.
5th January. Oh, 5th January. 5th January.
Yes.
Well, this has not been complied with by petition. Let them answer this.
So what direction was passed upon them?
Third paragraph.
Third paragraph.
Yes.
Possession certificate was issued to the petitioner and the construction. Produce all relevant documents in support of the position.
Here admitted, may I precisely tell you the facts. Their sheet anchor is a letter issued by the KMDA in 2008.
Yes, Mr. Patu,
whereby
did you construct with sanction plan? Please show me the possession certificate and the sanction plan.
Possession certificate is not.
Sanction plan.
Candidly, no.
How could you construct without a sanction
That is
plan?
not the subject matter before mine. But my lord cannot argue lordship at the same time. But here question is whether the Article 12 authority play with the consumers. Want land sold to persons.
That's neither.
That precise
But the
question.
question is the equitable relief.
That's true.
Whether a person is not approaching the court with clean hands, whether the reed court can.
It will be demolished.
Please demolish, thereafter I will consider. Please come, clean your hands. Come.
We'll refund the money.
Please clean your hands, then come.
This much is here, but sanction plan is not there.
But it could not. But it's within the area where the sanction is required.
Sanction is required, and in addition to that, I can say it is not offending any building rules.
Mr. Basu, that's neither here.
Justified. Don't take whether I am justified.
That's neither here nor there.
I'm not justified.
Then nobody will take sanction and say yes. I will maintain the building rules and make construction.
Board charge is not obstinacy clause. I cannot argue that. I'm not arguing. I'm giving a fact to before my lord. What is the lease here? Whether You take money,
But
give me a possession, give.
in equitable jurisdiction, Mr.
But
We are
when
in
you not
equitable
only for
jurisdiction.
me, for them,
All for all.
property,
But you have approached first.
right? But
You have
what
approached first.
deciding.
So he who seeks equity, Mr. Basu, there are
Doing good. Right.
He's relying on the agreement which plot has been cancelled. But even then, my learned friend should refer to 2 Roman 3, the last paragraph.
But this is for only for minor. No. It cannot be implemented unless my land ownership is not with me.
And this also, my lord, may kindly have a look, because it is
My lord.
yes, you will not ask me.
I চাইবো না।
My lord had asked me to take instruction.
Yes.
This is the stand. You are compared. First page, only first page, Lord, kindly have.
দুজনকে ভেজি। This is your stand.
No, never.
Mr. Talukdar, I appreciate, according to you, you have not given him possession. Now, if I correctly recollect the facts, he was allotted, or his predecessor was allotted plot X. But that could not be allotted to him.
Ultimately could not be given to him.
So you offered, if I use the expression.
Yes, exactly.
Yes, yes. I'm conscious about using those expressions.
Yes.
So you offered plot Y to Mr. Basu. So now Mr. Basu was under the impression plot Y has been allotted to him.
No, can pause there for a moment. In paragraph page 42, I have wrote to them, kindly give me possession.
Allotted. I said
Give me
plot
possession.
Y was allotted to him. Now there were several communications, correspondences. Mr. Basu is saying that I asked this give us possession and other things. Fact remains, admittedly, Mr. Basu is in possession of plot Y. Physical possession of what plot Y.
Yes, otherwise I cannot construct.
That is what I am saying, Mr. Basu.
Yes, I know. I forgot that I have civil code.
So he is in possession of plot Y. Now, you have allotted plot Y to Mr. Mitsu. So there is a dispute. Now, let us for the present assume that Mr. Basu do not have any rights in respect of plot Y. Let us assume for the moment that he does not have any right. But he had some right in respect of plot X.
Yes. Yes.
Can you allot plot X to Mr. Basu now?
Here, Lordship kindly appreciate that.
Or why you offered him plot Y?
Yes. I am coming to this. Lordship kindly appreciate. Let us explain first about Y.
First about X.
X.
Let us come to the root first.
Yes.
Because
X,
there is no dispute that he was allotted plot X.
But
why did not give him?
Physical possession of X was not given.
But he made the payments and other things.
Payment was made.
What was?
License was also executed, but subsequently for some reason or the other.
So you could not hand over possession.
Could not hand over possession.
So there was deficiency on your part.
On my part.
So he was not at fault.
Yes.
So if you could not give him that plot, yes, you are obliged to give him an alternative plot. So what is the alternative plot which you have offered to Mr. Basu?
Now I am coming to that. My lord, this license, this X was allotted in 1994, and 1998 license deed was executed.
In respect of X.
In respect of X, he has not praised the authority
for delivery of physical possession of 141.
Did you resume that plot?
No. This, as it appears from the record.
No, it was your duty to resume. Construction not done, not doing. You are resuming plot.
Does not come. We could not give him possession.
Cancellation of the
And
allotment.
he has not also take resort of any forum. That
Because Mr.
he has not.
You have offered him an alternative plot.
Yes. My lord, this has happened much later. Meanwhile, in 1995, white plot was given to the private hospital. In 95.
How could you give that?
No, 95.
There was no difficulty.
No difficulty.
So let us now plot why Mr. Mitso was entitled.
My lord,
Then
may I
how
few
could you
lines-
offer that to Mr. Basu?
My lord, few lines more. 1995, though white plot was given to the private respondent did not take any step further. He simply said type of the allotment. Resumption was not done by the authority. Of course, there is no step taken by the authority. After the death of the original allotee, the heir filed an application for mutation. Then only the thing came to the.
Mr. Talukar, you are maintaining a register with regard to this allotment.
Sometimes my lord knows it is very difficult to keep visual on each and every plot.
No. I'm not on physical vigil. I'm on documentary vigil.
That mistake
Show
was
me the
done.
register which you are maintaining with regard to allotment.
No, here, I'm not. Here in 2000, as it appears, in 2008, this particular plot, which was already allotted to someone else in 1995, that was offered to him.
How could he?
That was a mistake. That was a mistake. And
Who committed that mistake, Mr. Talukar? They are still in service. Those persons who have committed the mistake.
Certainly not. Well, this was on condition consent was asked. He gave consent.
Who gave consent?
The petitioner gave consent that he has no objection.
Because Mr. Talukar, he does not know that you have allotted to someone else. You offered him one plot. Maybe he inspected, you are satisfied. Yes, I am happy with that. You are not giving. He accepted that.
But plot was not given to him. This
Offer.
was an offer.
Yes.
He accepted that. So next course of action comes a formal allotment to be done from the end of the authority, for which till 2012 and 13, he was one after another. He was writing to the authority asking for fresh allotment. Allotment was not given. Allotment was not given.
Little correction, not for allotment. Possession advice.
No. Possession advice allotment. Yes. Still true. See
Mr. Basu, let him submit. Yes.
One thing, my lord, is hearing can he, while hearing, my lord, can you keep your lordship's mind section 27 of the Limitation Act? Admittedly, I am in possession for more than 12 years.
Only against the state.
Against the state. It's a government.
No, his right extinguished. I have the judgment.
Mr. Basu,
This extinguished is right.
only one thing which is troubling me is that there's a contempt or a contempt may be filed, because there is also an order of the coordinate bench which directs this plot to be handed over to them.
I showed you 1963.
Uh,
I am making a praying for review also of this order that I can do.
Whether this
63, yes,
I've shown you the other day.
that's the different thing altogether. But 63, I'm not saying this is not maintainable, but that bench, bench has passed an order.
I have done two-three matters.
Just to avoid conflict, let that be decided, because this is after all this writ petition, the prayer is in effect a recalling of that order. That's the ultimate effect.
It does not matter, my lord. What is the order there? To consider this case.
There was considered his case, it is not having been allotted or something.
No, specific direction.
There was specific direction
He said, I am not parties there. He said that I am the owner.
Yes. So it was directed to be allotted in his stead.
Yes.
Now you have challenged that order.
Why a read petition?
Yes, by a read petition. What is the effective order you want? You want recalling of that order.
Thereafter, you have to decide.
You want recalling of that
Right.
order. So in effect, your read petition is a recalling application. So now
At the outset, it's submitted.
please think of a situation: a person applies for an content for implementation and a recalling application is filed. Naturally, recalling is hard trap. Thereafter, content. This is the usual practice. So I think it would be better if it goes before that way.
Subject to correction, though. This court has jurisdiction. That's the 60th Supreme Court says.
Mr. Basu,
Had it
not a
been I got it. Recalling up that
having jurisdiction or not having
I will
jurisdiction.
not say that your lordship cannot refuse to exercise. I'm not saying so. But what I am submitting, had it been a case of recalling application or a review application of simplicity, that court has the jurisdiction. But here, extraordinary situation, extraordinary writ petition, 60th Supreme Court followed by other two judgments of your lordship's court says that the court who is taking up jurisdiction at present can take up.
At the instance of such a person who has no locus
So
standi,
that is separate. Said the majority said.
who has no locus standi, my lord, I was indicating page 40. Russia
Of
candidate.
the writ petition,
Russia candidate,
page 40, yes.
page 40. The second paragraph. I will not trouble your lordship. The first paragraph, last line, I want to construct a dwelling unit. This is writing in 2009. Then middle paragraph, to issue a fresh allotment letter. My lord has seen, is asking for allotment letter.
Now the property is FB 25.
FB 25.
Doesn't disputed is FB 25.
FB 25. Then your lordship kindly come to page 42.
Yes.
I have not received first paragraph, last two line. I'm placing it on. I have not received any letter regarding issuance of necessary possession advice. So without, my lord, I am asking myself, without possession, without allotment letter, without possession, how the petitioner could make construction? How could he say that FB 25 was under his possession?
So why did you offer FB 25 to him? What's the cause of action for offering this FB 25 to Mr. Basu?
FB 25.
Please show me that cause of action. Why you offered this FB 25 to Mr. Basu?
FB 25, that letter.
So why? What compelled you to offer FB 25 to Mr. Basu?
Not compulsion. Well, it was an erroneous allotment.
No. There was
Since
it was an erroneous allotment according to you because
erroneous offer, not allotment, offer.
Because it was prior allotted to you.
Much prior.
No, what prevented you from handing over the original plot to Mr. Basu? Please show me that.
Well, that fact is not here.
Well,
141 was.
please allot the original plot to Mr. Basu. I will direct him to vacate just now. Please allot the original plot to Mr. Basu's client. I will direct demolition. I will give you liberty to demolish.
I will arrange with my land insurance client. He will be allotting that plot.
Please allot the original plot to Mr. Basu's client.
140.
There is no difficulty, Mr. Talukdar, to allot that original plot to Mr. Basu's client.
No, original plot was cancelled.
Why?
Must be there must be some reason.
Mr. Talukdar, cancellation coupled with this alternative offer cannot be simpliciter now cancellation.
That was cancelled.
Mr.
That was
Talukdar
cancelled.
cannot be segregated. It was complete. Coupled with this alternative.
No, the plot are not adjacent.
Maybe. No, I'm not saying not adjacent. Coupled with that alternative offer.
No,
The single thing-
was cancelled. There might be there.
Please show me the letter of why you did not could not offer the original plot to Mr. Basu. What compelled you to offer?
The reason I have to take.
That is why I adjourned it to take instructions, Mr. Talukdar, everything.
That could not be allotted. That is why the alternative plot was offered.
I want to know the reason.
The reason.
Yes, entire decision. Because all decisions are to be taken. X, Y, Z reasons. I cannot offer this give possession to Mr. Y in respect of this. For such reason, this was the decision. Please show me those decisions.
If your lordship, my lord, as your lordship desired, I obtained that instruction. I have handed up.
What instruction?
The first page, only the first page. The document need not say, lordship need not say. The first page, two paragraphs only. Only
Yes.
one page.
Tell me what is your instruction?
Yes. That reasons are not disclosed there.
No, inadvertent mistake is with regard to FB25.
Yes.
But you are obliged to offer an alternative plot. Which plot you can offer the petitioner now? This was your mistake, I appreciate.
This
But-
has to. This
Yes,
has to.
but there was a license agreement in respect of another plot.
Not
You are obliged, not FB25, accepted. So you are obliged to offer him another plot. Please show me that. Which plot you can offer him now?
This plot we cannot. This plot.
Another plot. This plot accepted, you cannot.
Well, that instruction we have here. That
So
instruction.
Calcutta, that you have to take.
That instruction.
Because he is entitled to get one plot. He has complied with everything. License agreement was also done.
My lord, if we cannot, we can also, my lord, return back the money we have received.
Return back the money to Mr. Mitra. Return back the money to Mr. Mitra. He has not done anything. He has not altered his position. The Basu has altered his position. Return it to him. If he accepts.
We are not favoring anyone.
No. I am giving that
We are not
because Mr. Basu has altered his position. He has not.
But whether lordship, this court will appreciate the conduct of this
Mr.
petitioner.
Talukdar, can you offer Mr. Basu an alternative plot?
Well, I will take instruction and come.
What for this was adjourned, Mr. Talukdar?
My lord, this instruction, I have not.
This instruction you are saying through inadvertence it was given to him. That's neither here nor there. That you have submitted on the last session. I'm not interested in hearing that by mistake you have given.
My lord is
But,
very clear that MB20, my lord is not appreciating that. My lord will ask
No,
for demolition.
FB25 you need not give. Give him another alternative plot which is
The weather can be
free from all incumbents.
weather can be. If your lordship kindly.
This is in which area?
There two houses are made with a common one. Because
Where?
Kushumkata particularly,
Yes.
there are two plots are.
No, you do not have any vacant plot there.
Whether there is an possibly not. Even then I shall inquire.
In which area you have?
Particular area, if there is no vacant lot, then it will be very difficult.
You will state it on affidavit. Then you will not come up with any auction and another thing in future. I will record that. That will be the court's order that the KMC do not have any vacant plot.
Let me come. Let me come back. Whenever
You take instruction.
desire to. But AP25 that should.
I am not saying FB25. Please give an alternative plot.
Yes.
Because he is entitled to one plot. May not be FB25.
One line, recording.
What?
One line. That will.
My line will be court's order. I will not record anything. It will be on your prayer I will adjourn this. Or I will proceed on the basis of the materials. I will not say.
No gun on the shoulder of the court. No gun.
Only one line would help.
Not.
From your mouth, not by court. Otherwise, I will proceed on the basis of the materials I can hear this.
Let me try once more.
After some argument, Mr. Talukdar and his advocate
After
12, 12.
এই, 27 হয়ে গেছে। বাহ, কি ব্যাপার?
Patient is handed over with a bunch of documents produced by the we have asked him. He said the drivers again.
Yes.
So I have gone through these documents and what is revealed now. So initially I was told, my client was told by them that he is because of the excess amount of land. But documents that have it says that this is a case for expiry of the challan.
This file taka ba?
The
Yes, expiry of the
challan. And what I find, putting aside other documents, whether these are genuine or not, whatever has been annexed with, I want to when it comes to this rule that is rule 15 of the specific rules, which is also given by them. This is known as West Bengal. This is known as the West Bengal Stand Mining Transportation Storage and Sale Rules 2021. Or please will have the copy once in the document. Will kindly come to rule 15.
sand mining transportation storage and sale rules.
Yes.
Storage and yes. Rule
15. My lord, this is chapter 5, general restrictions on transportation, storage and sale of sand. Then prohibition on transportation, storage and sale of sand. No person shall transport sand without being duly authorized by the state government and carry valid internal permit or any challan generated on the centralized profile, which I do have. 2. No person shall store and sell and or carry out any other allied activities without being duly authorized by the state government. This is what the allocation is. A person engaged in the transportation of sand shall register itself and every carrier used by it for transporting sand on the centralized portal in such manner as may be specified in the state government in the notification published in the official gazette. A person engaged in the storage of sand shall register itself and every such stockyard depot used for storage of sand on the centralized portal in such manner as may be specified by the state government in a notification published in the official gazette. A person shall engaged in sale of sand shall register. It's not applicable. Persons specified in rule 3, 4 and 5 who are engaged in transportation and or storage or sale of sand from before the commencement of this rule shall register. It is also not applicable. Within such time, any act may be specified by the state government in a notification published in the official gazette. Such other persons engaged in the activity in connection with the sand, if not already registered on the date of publication of such notification. The time period, terms and conditions of the registration and fees shall be specified by the state government in the notification published in the official gazette. The expiry of the challan is not a ground for imposing the penalty, particularly in a situation. My lord, kindly come to the documents provided by them. Would you kindly come to after this rule? Certain pictures have been appended by. Would you kindly
after
come
this rule. Yes, yes.
after this? Now, Lord, you kindly see the column 3. This is checking can be done either by keying in the vehicle registration number, scanning QR code on the e-challan produced or entering the e-challan. Now, Lord, what is suspicious here? Lord, you see, this is online e-challan which is generated online. But kindly see here, it is endorsed genuine but expired. Challan is genuine. It's not numbered. It's
So,
immediately after the.
My copy, here's some number.
Yes. This is maybe page number 9. This is page 20, 21.
21.
21. 20 is missing in my copy. Now 21.
Yes.
Now still, your lordship,
Yes, genuine. You had the challan, but the time expired.
and expiry of the time is not an offense under this act. This rule. And now this has been imposed. In the lieu of that, I am carrying the excess amount of sand. So lordship, this is not a case.
Where is that allegation that we are carrying excess?
My lord,
amount of-
initially, lordship, I was not given any handed over with any paper. Lordship, kindly come to they are only now saying that it is a case of this. Lordship, kindly come to this one page initial state. The documents only shows, Lordship. Kindly last page also, Lordship. This is the genuine but expired. That's the only thing. And the timing valid till 6/12/2025, 12:42 AM.
No, which says that it was carrying, I think, some document you have shown on the last occasion that it
Yes.
was carrying.
That is in my
measurement. Where?
in our supplementary affidavit.
Yes, supplementary affidavit, which document?
GPS track was given, my lord.
No, GPS track report is it was driving or stoppage.
Yes.
No, that excess measurement, I think, in some document.
That is not document, Lordship. You were told by them. In the other matter, it was a specific case.
Oh, in the other matter, not in, I think, not in this.
But
matter.
in this case, Lordship, that was the reason why I was we were told that you are carrying this loading capacity and extra after this repetition, these are manufactured, according to me. They wanted to, Lordship, cover up something maybe, but which I don't know. But I, according to me, my lord, I had a very valid challan as on date, that is 6/12. That day, I had the challan, and transportation began at the appropriate time. My lord, I am asking this question to myself. It has not reached within the time. It was the same. If it is also true, if their version is true, I was carrying that challan. On the basis of that challan, the vehicle should have been reached to the final point. In the meantime, that has been expired. If it is a case that there is an obstruction on the road, am I doing anything illegal? It is not a case of excess sand. So that is my case, my lord.
So, what is your case? Why there was a delay? Why it did not reach the destination within the time?
My case is that I reached at the appropriate time. That's why I am giving the GPS track. Lordship may find out from the GPS track. They are kindly. I'm just telling the Lordship that it was valid according to them till 6/12/2025, 12:42 AM. Now, Lordship, kindly come to my supplementary affidavit, page 7.
Yes.
6:45. Then Lordship, kindly come to page number.
Where were you supposed to go?
We were supposed to reach at. It started from. Haripal to Jagadishpur, Howrah. Now, Lordship, kindly.
From Jagadishpur Homeo Pharmacy.
That was the Lordship, kindly come to page 10, last page. Lordship, here it's a 5th December 2025 at 23:23. It was at 123 meters from Kedarnath Cold Storage, Ahiliabari by Holkar Road, Jagjibanpur, Horipal, Hubli. So it was at 23 hours of 5th December 2025. It was the starting point.
Yes. What is the
It is the
destination?
ending point.
What is the destination?
Lordship, destination, Lordship, will find from page 7. Destination detail was Howrah, Rinua Howrah.
Yes.
And now, Lordship, will find it. Page 7.
Where do you find that the destination is Lilwa Howrah? Where from?
My lord, in page 24 of
Yes.
my, this is the challan.
Yes.
Lordship, kindly come to the challan, page 24 of the repetition.
Yes.
Lordship will find permissions holder details.
Yes.
Gopinath put 2 and on the right hand side vehicle and destination details.
Yes.
District Howrah state such and such vehicle number capacity. Now prior approval was accorded by ADM and DLLRO Hooghly.
Oh, so destination is Lilua Howrah,
Howrah.
but you did not reach Lilua Howrah.
Because I stopped there, I was forced to stop there.
Not forced to stop. You are intercepted at that.
And
Whether you are forced to stop or you stopped for taking meals, that's
No.
for you to.
Now, Lordship, kindly see the timing. Their time is 6:42
Yes,
hours.
but after that, there is no GPS track. It's not your case that you are intercepted on that time. Please show me that you are intercepted at.
It is their stand. It is now their stand. They have intercepted.
When they have intercepted after the expiry, not at 23:59 on 5th of December.
Well, they have intercepted. They are showing they have done it after.
What is your case? When you are intercepted, please show me.
My lord, as per these documents,
not these documents, your statement on oath when you are intercepted.
But that's why we made the supplementary affidavit, my lord.
Show me from the supplementary affidavit what was the time when you were intercepted.
My lord, kindly come to paragraph 5, respectfully state the operating strictly within the validity period system generated e-challan dated 5/12/2025 issued at 9:42 p.m. and the entire journey from loading point to unloading point was undertaken lawfully. That the vehicle commenced its movement from the authorized loading point, and 7. That the interception of the petitioner's vehicle by BLLR Haripal took place on 5/12/2025 at 11:49 p.m. hours. So they have only increased that. They were waiting for the.
How can this disputed fact be decided in a writ petition, Mr. Chatterjee?
Well,
whether that was intercepted on 11:49 or 2 hours after?
Now the question is, my lord, whether the interception itself will be valid in view of Rule 15. That's why I started with Rule 15.
So interception is another thing. Interception can be intercepted
Yeah,
at any point of time,
but
if
whether
you
it
ask
can
you
be
to produce those documents. That's one thing. Second is, even if it is beyond, whether penalty can be levied. That's the point.
That's the point. Whether
yes,
it is
Mr. Debra, if it is whether there is any procedure for validation of the e-challan.
I inquired about it last time with the he said, madam, immediate vehicle constant breakdown, if any breakdown is occurred, then madam, the person concerned which in charge of the vehicle immediately intimated to the concerned officer.
So the e-challan will be validated again.
No.
Then what will be done? Then it can't be transported.
Then it can't be transported.
What will be done?
Then they have to apply a face. Then they have to apply a face. That is chapter is over. That chapter is over up to 242. His e-challan is valid. Thereafter, he has to mention that why they have not covered within that time. Then, my lord, authority, after considering the facts, then, my lord, they decided to grant or not grant. That is there. After taking photographs where the vehicle situated at, that has to be done.
GST একটা আছে এখানে?
This is my instruction.
GST একটা আছে? GST
Maybe.
There is a provision for validation, so it has to be done within that time. But your statute do not contemplate that.
Maybe come back on Monday.
No, in that case, Lordship can direct the petition to prepare an appeal. There is provision for appeal, section 232.
There is no order which has been.
Yes, order has been passed.
Where is the order?
Where
which
is
has
it?
been
It has
passed?
not been
It is
communicated.
PLRO order. I have submitted, Madam, 17/12/2025.
Page. Where is the order? Copy of-
Instruction is there, Madam.
No, please give him the copy of the order,
It's an instruction.
not the instruction. It is the copy of the order imposing penalty.
Kindly give it. I shall serve this.
Please bring the copy of the order. I will direct him to.
Madam, that is better, Madam. It is a factual
Because
aspect of the
Mr. Chatterjee is a
In
factual
that case,
aspect.
also, I can challenge the order also after examining it.
Yes.
Even under Article 226 also.
When?
Lordship, kindly, there is a Friday. Next Wednesday or Thursday, I shall.
On the heard Mr. Chatterjee, learned advocate for the petition on the
No, matter will appear on.
15 yes.
I tell matter is appear on
12 you said
12.
item number 23.
Much obliged, Madam. 2300.
23 350 এটাই তো হলো
23.
13. So 13 who is appearing?
Madam,
Yes.
I'm the advocate on recording this matter, madam. Due to some difficulty, madam, I have managed to effect service upon the office personnel and
Yes, what is this matter? What is there in the writ petition? There is no necessity to serve even. You can move.
madam, I'm a owner of a SME organization, madam.
Yes.
It is duly registered under the and my business is about sand gradation processing. Sand gradation processing. My business.
Yes.
And the end product is a filter material which I supply to.
What is the dispute which you have raised in this writ petition? You have paid blanket order, restraining police, restraining BLRO, everyone from doing what?
They are obstructing my.
Why they will obstruct you? You don't have documents. You are transporting sand without documents.
I have documents, I have annexed it.
Yes. What documents you have annexed? Why they are interfering with your business? Interfering with the day-to-day business as big a prayer as you have made in the writ petition. How they are interfering? What's the cause of action? No cause of action has been disclosed in this writ petition.
They are prohibiting me to stack land, stack sand in my premises, but
They are permitting.
They are prohibiting me to
Show me how they are prohibiting you. Any document.
No document. They
Then-
have not served a notice.
Then
But they are day to day. They are coming to my premises and obstructing my.
which paragraph you have stated that?
And it's,
You have filed an application dated 5th of January 2026,
Madam.
praying for permission. Have you got permission? So without permission, how can you stack?
kindly make it not to the
What not today, sir? No, the cause of action has been disclosed here. Without permission, how can you stack? They are rightly interfering from your business. You don't have any permission.
Kindly make it not to the I need further instruction, from my client. I need further instruction. Kindly make it.
After some argument,
159.
158, what happened?
150 whatever the till end of January.
158.
No, it has been fixed at 2 p.m. Monday.
2 p.m. Monday.
No, it was fixed for minute, but matter was not
The
fixed.
matter
This is this. देखिए, 158. Hey, but what is this matter?
No, no,
You are an encoder, Mr.
that
Moore.
he's
Let me see.
it was going to be dismissed by your order.
Going to be dismissed, and he got an interim order.
Yes.
Dismiss in the next week. Only extension of interim.
Enjoy the weekend, Mr. Ghosh.
My specific submission was without considering the illegal demarcation was done.
On third, it
Now
has been
whether this is permissible or not, if considering the illegal demarcation,
because
Everyone is saying it is not maintainable. Only you are saying it is maintainable.
in the next week, I shall make my submission whether it is maintainable and after hearing my last
I tell you.
minus plus necessary.
কবে রাখবে
Sir, তবে রাখতে বলবেন তবে
তিনে নাই পাঁচে লিখে দাও
পাঁচে হবে না পাঁচে
কবে
তিনে হবে।
ফাইলটা কোথায়? Reach 158 in a day.
There is 3:30 morning, we are waiting.
No, no, I was leaving. Gujarat ছেলেটি বললো
আরে সভ্য ওয়ান ওইটা ওয়ান আমরা একসাথে
তিনে বা It has been established that they are aware of all. Map is there, everything. Your lordship's query was to bring the map.
By which order this interim order was passed?
order dated 8th of December 2019.
5th of December.
কুড়িয়াকে
That was the last extension. Last
এই তো কুড়িয়াকে আছে
No, when the initial order was passed of
আজকাটাতে 11
restraint from 1911. Restraint from giving effect to what was that order? 13th of August. DN that is 10-3, 10-4 order.
Yes, my lord.
So you could not succeed in before 2 forum. 10-3, 10-4.
Due to my specific case, the demarcation was not when considering the LMF. Both the authorities below accepted that without the considering.
Copy of the report was given to you.
I raised objection, and my specific objection was that to that effect that was not considered. For that, it is my direct
Concurrent findings are there. They are the
Concurrent findings of fact.
facts, no, everything.
I shall try my.
On the last occasion, he tried his best.
So can for
Can for extension of can be for extension of the interim.
can 2 is extension of can 1 was also for
Can-
extension.
Can one disposed of
Can
by
1
order
disposed of
dated-
condition. Can 1 disposed
দুটো ব্যাটারি একটা করে
159 158 can 2 আছে. Where is that application? Where are filing applications for extension? Where are filing applications for extension? Nowadays, this practice has started in appellate side. File applications for extension.
Some of the honorable courts are saying to file application either way and
within time.
Yes.
দেখি ক্যানগুলো কোথায়?
And copy the